California Consumer Privacy Act, Part 1. Before we dive into the law itself, it's important to understand why California adopted the CCPA. For many years, companies collected enormous amounts of personal information: what people searched for, where they traveled, what they purchased, and even how they behaved online. Most consumers had very little visibility into what information was being collected or how it was being used. At the same time, several high-profile data breaches and privacy scandals, including the Cambridge Analytica incident involving Facebook, raised public concern about how businesses handled personal data. California responded by becoming the first U.S. state to pass a comprehensive consumer privacy law. The goal of the CCPA was simple: give California residents greater transparency, more control over their personal information, and hold businesses accountable for how they collect, use, share, and sell personal data. One of the biggest events that changed how people think about data privacy was the Cambridge Analytica scandal. In 2018, it was revealed that a political consulting firm called Cambridge Analytica had obtained personal information from millions of Facebook users without their knowledge or meaningful consent. The data was originally collected through a personality quiz app, but it also captured information about many of the users' Facebook friends. The company then used this data to build detailed profiles of voters and deliver highly targeted political advertisements during election campaigns. The scandal highlighted how personal information could be collected, shared, and used in ways consumers never expected. It sparked worldwide concerns about online privacy and became one of the key events that accelerated privacy legislation, including California's Consumer Privacy Act. Let's look at the timeline of California's privacy law. In 2018, California passed the California Consumer Privacy Act, or CCPA, making it the first comprehensive consumer privacy law in the United States. The law became effective on January 1, 2020, giving California residents new rights over their personal information, such as the right to know, delete, and opt out of the sale of their data. Then, in 2020, California voters approved the California Privacy Rights Act, or CPRA, which amended and expanded the CCPA. Most of the CPRA's provisions became effective on January 1, 2023. The CPRA introduced new consumer rights, created the California Privacy Protection Agency, added protections for sensitive personal information, and expanded business obligations. Today, when people refer to the CCPA, they usually mean the CCPA as amended by the CPRA. To determine whether the CCPA applies, we first need to understand what the law considers a business. An entity must satisfy all four of the following requirements. First, it must be a for-profit legal entity. Second, it must do business in California. A company does not need to be headquartered or have offices in California. Even a business located in another state or country may be subject to the CCPA if it conducts business in California. Third, it must collect consumers' personal information, or have it collected on its behalf, and determine the purposes and means of processing that information. In other words, the business decides why the data is collected and how it will be used. And finally, it must meet at least one of the CCPA's statutory applicability thresholds, which we'll discuss on the next slide. If all four requirements are met, the organization is considered a business under the CCPA and must comply with its obligations. Meeting the first three requirements is not enough. A business must also satisfy at least one of the CCPA's applicability thresholds. The first threshold is annual gross revenue exceeding the amount established by the CCPA, which is adjusted periodically for inflation. The second is buying, selling, or sharing the personal information of 100,000 or more California consumers or households in a calendar year. And the third is deriving 50% or more of its annual revenue from selling or sharing consumers' personal information. A business only needs to meet one of these three thresholds. If it also satisfies the other requirements we discussed on the previous slide, it will generally be subject to the CCPA. The CCPA protects consumers, but who exactly is a consumer? Under the law, a consumer is a natural person who is a California resident. In other words, the CCPA protects individuals, not businesses or other legal entities. The definition of a California resident generally includes people who live in California for purposes other than a temporary or transitory stay, as well as California residents who are temporarily outside the state. When the CCPA was originally enacted, most of its protections applied in the consumer context, primarily to customers. The CPRA later expanded the law by extending many of those protections to employees, job applicants, contractors, and business-to-business contacts. We'll discuss those changes later in this presentation. One of the most important concepts under the CCPA is personal information, often abbreviated as PI. The CCPA defines personal information as information that identifies, relates to, describes, is reasonably capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. That's a very broad definition. In simple terms, if information can identify a person or household, or can reasonably be linked back to them, it is likely considered personal information under the CCPA. Examples include a person's name, email address, phone number, home address, driver's license number, IP address, geolocation data, online identifiers, purchase history, browsing activity, and even inferences drawn to create a profile about a person's preferences or behavior. The original CCPA gave California consumers 4 fundamental privacy rights. First, the right to know. Consumers have the right to know what personal information a business collects, uses, discloses, or sells. Second, the right to delete. Consumers can request that a business delete their personal information, subject to certain exceptions. Third, the right to opt out of the sale of personal information. Businesses that sell personal information must provide consumers with a way to opt out of those sales. And fourth, the right to non-discrimination. A business cannot discriminate against a consumer simply because they choose to exercise their CCPA rights. These were the 4 original rights under the CCPA. Later, the CPRA expanded them by adding new rights, which we'll discuss later in this presentation.